Order. Ben Lake to move the motion.
Thank you, Mr Turner. It's a pleasure to serve under your chairmanship, and I should like to beg to move that this House has considered miscarriage of justice compensation. Now, Mr Turner, I should like to wager that the majority of citizens in this country are relatively unfamiliar with the workings of the criminal justice system, and less still with miscarriages of justice. Perhaps, if they are aware of miscarriages of justice, they'll be aware of certain high-profile exonerees or cases of miscarriage of justice, such as the Cardiff 3, the Guildford 4 or the Birmingham 6. However, most will understandably, and quite reasonably in my opinion, assume that victims of miscarriages of justice are compensated, particularly if they have spent time in custody before being pardoned or having their convictions quashed. However, this is not the case. For cases in England and Wales, compensation for the wrongly convicted is the exception rather than the rule. The current compensation scheme only enables some people in England and Wales who have had their convictions overturned, who have been found not guilty at retrial, to receive compensation. Now, I should like to be very clear that my concern in this debate is not that miscarriages of justice happen. Sadly, no system in the world is perfect. And so miscarriages of justice will happen because we cannot get it correct 100% of the time. However, when miscarriages of justice occur, citizens expect the state to right that wrong. Indeed, according to a December 2024 survey by Opinion, 71% of those asked believe the government should ensure fair and swift compensation for those wrongly convicted. Many will therefore be appalled to learn that this is not the case, that victims of miscarriages of justice seldom receive compensation for the wrong that's befallen them, that the wrongly convicted too often have to fight for years at great cost to clear their names, that the justice system unnecessarily forces the innocent to suffer continued injustice. It is the failure of the state to right these wrongs that is at issue here today. For we should be clear, a miscarriage of justice inflicts considerable harm on the wrongly convicted. A 2018 report by the campaign group Justice, entitled Supporting Exonerees, Ensuring Accessible, Consistent and Continuing Support, underscores the grave hardship, the difficulty that the wrongly convicted have in adjusting to life after the conviction, the trauma that they have gone through, and the way that they have to deal with this for years after the event in question. The report highlights how victims of miscarriages of justice struggle to adjust. They struggle to trust authorities, having spent years in prison, both becoming institutionalised and also grappling with the very fact that they should not be there. Now, the unfairness of the current system was brought into very sharp relief for me, Mr Turner, when I met my constituent, Mr Brian Buckle, and his family, and learned of their experiences. And I'm very pleased to say that they have made the journey from Fishguard today to be with us in this chamber. Now, in May 2017, Mr Buckle was convicted of 16 counts of historical sexual offences and was sentenced to a total of 15 years imprisonment. He had always maintained his innocence. And in September 2022, the Court of Appeal overturned his conviction and ordered a retrial. He was immediately released on bail by the Court of Appeal, having served 5 years and 4 months of his sentence. Now, the retrial took place in May 2023, for which Mr Buckle and his defence team, led by Mr Stephen Vullo KC, who is also with us this afternoon, prepared a detailed defence and presented new witnesses and forensic evidence. After 3 long weeks of deliberations, the jury returned unanimous not guilty verdicts in just over an hour. Now, I cannot fathom the strain that Mr Buckle has endured from years of legal proceedings and the travesty of being imprisoned for a crime that he did not commit. Let us remember the impact that the wrongly convicted must go through. He missed important family milestones, such as his daughter's 18th and 21st birthdays. His imprisonment cost him more than $500,000 in income and devastated plans to retire at the age of 55 with a private pension, having not been able to make any contributions since his imprisonment. And furthermore, his state pension is also now in jeopardy, given that he was unable to make any national insurance contributions for over 5 years. So the impact is not limited to the period in which he was deprived of his liberty. I'm afraid to say, Mr Turner, that Mr Buckle has been diagnosed with PTSD because of the impact of this wrongful conviction and his imprisonment. And his mental health is such that he has been unable to work since his release. Members, I should like to just explain that Mr Buckle, prior to this awful state of affairs, used to travel every week from West Wales to London, charge of an engineering firm. A very important, very responsible role, which he did for over 15 years. Made that journey, that weekly journey, along the Great Western Main Line or the M4, which indeed the Minister and I must make on a weekly basis. And the point I make here is that this travesty can befall any one of us, for no fault of our own. And although it's difficult to comprehend the nightmare that's befallen Mr Buckle and his family, one can begin, perhaps, to estimate the financial impact of the ordeal in terms of the income and pensions lost. Perhaps we can also put a figure on the costs incurred for appeals and legal defences. But how can you begin to calculate the impact on his health or the loss of precious time with family members? A difficult dilemma, I'm sure we'd all agree, but not, it would seem, for the Ministry of Justice, which issued a cruelly simple response to Mr Buckle and his application for compensation under the statutory scheme. In the decision letter issued almost a year after the application was submitted, it rejected his claim out of hand, Mr Turner, stating, "Having carefully considered the particular circumstances of the reversing of your conviction, I do not consider your case demonstrates beyond a reasonable doubt that you did not commit the offences for which you were convicted." Mr Buckle spent 5 years and 4 months in prison, had his conviction overturned by the Court of Appeal, produced a detailed defence including new witnesses and fresh forensic evidence at retrial, at which the jury, I remind you, Mr Turner, unanimously returned not guilty verdicts to all 16 counts in just over an hour. Now, having been subjected to all this ordeal, having jumped through all of the hoops one would expect of him, the Ministry of Justice response is not only to deny him compensation, but worse, to state that they do not consider that his case demonstrates beyond a reasonable doubt that he did not commit the offences for which he was convicted, or those same offences for which he was acquitted. No reference to the harm that he suffered, or the impact on his family, or that the Court of Appeal was so concerned that the original trial was so flawed that the jury had failed to approach their task correctly, that it ruled the conviction unsafe, such that the new witnesses and fresh forensic evidence was unnecessary. All that he had was a pretty meaningless reassurance that the matter has been carefully considered. Now, if this, Mr Turner, is what comes from a careful consideration of the matter, I dread to think what would result from a reckless handling of it. But it surely could not be much worse for Mr Buckle, for after years of legal battles and wrongful conviction, he is told that although he is not guilty, the state will not compensate him for the years spent in prison, because it does not believe he has proven his innocence. One does not need to be King's Counsel to see the unfairness of this situation. There can be no doubt that such a decision prolongs the miscarriage of justice in Mr Buckle's case, and it is wrong that this new UK government can and must put right. Now, before moving to how the new government can do so, it is worth reflecting briefly on how we've arrived at the current situation. Before 2006, the government operated 2 compensation schemes for victims of miscarriages of justice in England and Wales, a discretionary scheme and a statutory scheme. Now, the discretionary scheme was abolished in 2006, but the statutory scheme afforded the Justice Secretary discretion to pay compensation to a wrongly convicted person when, and I quote, his conviction has been reversed or he has been pardoned on the ground that a new or newly discovered fact shows beyond reasonable doubt that there has been a miscarriage of justice. In 2011, the Supreme Court ruled that the meaning of miscarriage of justice for the purposes of the statutory scheme should not be restricted to applicants who are able to conclusively demonstrate their innocence, and should be extended to cases where a new or newly discovered fact so undermines the evidence against the defendant that no conviction could possibly be based upon it. However, in 2014, the then UK government legislated to reverse the effect of this decision. The test for eligibility for compensation under the statutory scheme, as set out in Section 133 of the Criminal Justice Act 1988, was amended by Section 175 of the Anti-Social Behaviour, Crime and Policing Act 2014 in such a way as to restrict compensation to those who can prove innocence beyond reasonable doubt. And so, for applications made to the statutory scheme on or after the 13th of March 2014, there will have been a miscarriage of justice if, and I quote, and only if, the new or newly discovered fact shows beyond reasonable doubt that the person did not commit the offence. Now, Mr Turner, this modest rewording of a single section of an Act of Parliament has proved devastating. Indeed, it's legally illiterate to effectively reverse the burden of proof in this way, for it places a burden upon the victim of a miscarriage of justice to prove their innocence. This is such a high bar that it represents, in the words of the joint dissenting opinion of judges at the European Court of Human Rights in the matter of Neelan and Hallam versus United Kingdom, represents a hurdle which is virtually unsurmountable. And such a claim is not solely a matter of opinion, but also an observable fact. The data on applications to the Miscarriage of Justice Application Service shows that under 7% of applications submitted between April 2016 and March 2024 were successful.
I've always believed, and the honourable gentleman is probably the same, that you're always innocent until proven guilty. It seems to be what they're saying is you're actually guilty, then prove yourself innocent.
Well, my honourable friend has got to the nub of the matter. That is precisely what the effect of this change implemented in 2014 has had. And it is devastating for the number of successful applications for compensation. Because if we consider the data for the period between 1999 and 2024, we can see that prior to the introduction of this new Section 133 test, 45.6% of applicants were receiving compensation for their wrongful convictions. Following its introduction, just 6.6% of cases were approved, a percentage drop of 39%. Now, this new test has virtually put a stop to compensation payouts for these kinds of miscarriages of justice, an insurmountable hurdle indeed. But members now may wonder as to the purpose of restricting eligibility in this way. And I'm sure you'll hear arguments that it was done to prevent those exonerated on a technicality from receiving compensation. But the cynic in me, Mr Turner, fears that the restriction was introduced to cut costs. Prior to 2014, the Ministry of Justice made an average annual payout of £5.9 million. Following the change, we see the average annual payout under the scheme drop by 95% to an average of £297,000. Even successful applicants have seen their individual compensation payments fall, with the average pre-2014 payment totalling just over £267,000, falling to an average of £61,000 after the change. Now, I'm reminded of Cicero's teachings over 2 millennia ago that justice looks for no prize and no price. It is sought for itself. He also said, of course, Mr Turner, that the worst kind of injustice is to look for profit from injustice. Now, it is for others to consider whether anyone profits from this injustice, but the savings that the 2014 test realises for the Minister of Justice perhaps offer a quote as to that age-old question of what price do we put on justice? Well, I can tell you, Mr Turner, it's around £5.6 million per year on average when compared to the post- and pre-2014 payments. The current system, therefore, places an almost impossible burden upon the applicant, one whereby they are required to find a new fact which shows beyond reasonable doubt that they did not commit the offence for which they have been acquitted. The perverse situation into which the 2014 change forces the wrongly convicted can be summarised as follows. They are required to prove that they are innocent of a crime for which they have already been exonerated. And it's an academic point, I appreciate, But it is worth considering whether some of those past high-profile exonerees, the cases of the Cardiff 3, the Guildford 4 or the Birmingham 6, would actually receive compensation if they made those applications under this scheme today. Now, to the layman, it is difficult to understand how such a situation is compatible with the principles underpinning our justice system, for it undermines that well-understood principle that we are all innocent until proven guilty. Now, I know there might be a challenge on this assertion, but the fact remains that the current rules place the obligation on the defendant to prove they did not commit a crime, to the criminal standard of proof, which is beyond reasonable doubt. But let us return to Mr Buckle's case. In his rejection letter, the Ministry of Justice, as well as reassuring him that his case had been carefully considered, asserted that despite rejection, his claim for compensation, he is still presumed to be and remains innocent of the charges brought against him. Well, if you are ever looking, Mr Turner, for a definition of Orwellian doublespeak, this response provides a perfect example of it in practice. And it illustrates the way in which the 2014 change, by reversing the burden of proof, undermines the presumption of innocence and forces the Ministry to perform quite impressive but legally illogical linguistic gymnastics. For if Mr Buckle is, in law, presumed to be innocent, then surely he must be treated as such by the state. A man presumed to be innocent who has spent over 5 years in jail should be compensated. And if the state wants to treat him as though he were a guilty man and deny him compensation, why should the burden not fall onto the state to prove his guilt? Claims by the Minister of Justice...
For approximately 65 minutes for divisions to take place in the House. There are multiple divisions. We're expecting several votes, so 65 minutes will be back. If we get back earlier than that and all members are in the place, then I'll recommence the debate. Thank you. Order. We'll start where we left off. There will be injury time added to the debate, so I'm expecting to finish the debate at 5:13 p.m. Mr. Ben Lake.
Thank you, Mr. Turner, and I'm very grateful for the additional time for us to conclude the debate today. Prior to the interruption for the divisions, I was just reiterating how perverse the situation is that the 2014 change has forced the wrongly convicted into, and that it can be summarised as follows: that they are required to prove that they are innocent of a crime for which they have already been exonerated. And, of course, Mr. Turner, to the layman, it is difficult to understand how such a situation is compatible with the principles underpinning our criminal justice system, for it undermines that very well understood principle that we are all innocent until proven guilty. Now, I know this can be challenged in practice, but the fact remains that the current compensation rules place the obligation on the defendant to prove that they did not commit a crime, of course, that they have already been acquitted, to the criminal standard of proof, which is beyond all reasonable doubt. And so if I can return now to my constituent Mr Buckle's case. In its rejection letter, the Ministry of Justice, in addition to reassuring him that his case had been carefully considered, asserted that despite rejecting his claim for compensation, he is still presumed to be and remains innocent of the charges brought against him. Now, if you ever are looking for a definition of Orwellian doublespeak, Mr Turner, this response provides a perfect example of it in practice. And it illustrates the way in which the 2014 change, by reversing the burden of proof, undermines the presumption of innocence and forces the Ministry to perform quite impressive but illogical linguistic gymnastics. For if Mr Buckle is, in law, presumed to be innocent, then he must be treated by the state as such. A man presumed to be innocent who has spent over 5 years in jail should be compensated. And if the state wants to treat him as though he were a guilty man and deny him that compensation, why should the burden not fall onto the state to prove his guilt? So claims by the Ministry that Mr Buckle is still presumed to be and remains innocent of the charges brought against him ring rather hollow when he is also denied a single penny in redress. It's clearly an affront to justice that the eligibility test prevents those who have been wrongly convicted of enjoying the full and unconditional benefits of being presumed innocent. Now, there's growing acceptance for the need for action in this matter. And sadly, the list of miscarriages of justice that have not received as much media attention, perhaps, but that are just as deserving of compensation grows ever longer. I could mention cases such as that of Sam Hallam's, who was imprisoned for 7 years, Victor Neelan, who was in prison for 17 years, and Oliver Campbell, who spent 11 years in prison and a total of 34 years fighting to clear his name. All have suffered unimaginable harm as a consequence of their wrongful convictions, and just like my constituent Mr Buckle, deserve justice. Now, the new UK government has an opportunity to do so, and I would urge them to address this injustice without delay. For I know that the Minister will agree with me that the principle that the state should compensate those who have wrongly been deprived of their liberty by the state. And I'd welcome confirmation that this is also the government's position when she sums up and responds to the debate. The Law Commission, Mr Turner, is also currently consulting on reform to the law governing criminal appeals, because they too acknowledge that the current state of affairs is completely unfair. Now, this intervention by the Law Commission is to be welcomed, insofar as it acknowledges the unfairness currently placed upon the wrongly convicted. Now, in its consultation, the Commission suggests that if the burden is to fall on an accused to prove innocence, to obtain compensation, it should be to the civil standard, rather than the criminal standard, as is the position in every other situation in a criminal case where the evidential burden shifts to the defence. It would therefore be bringing things into line with a normal state of affairs. And so I would ask the Minister, in responding to the debate, if she can offer the government's position on the proposal that has been made by the Law Commission, and would the government accept such a recommendation if made by the Commission, and if it is minded to accept, will it ensure that the recommendation is applied retrospectively to those wrongfully convicted since the 13th of March 2014? And so while I air a note of cautious welcome to the intervention of the Law Commission, and agree that while it would make the situation fairer than it currently is, it still doesn't explain, to me, Mr Turner, why someone who is presumed to be innocent has a further obligation or burden to prove it. And neither would it address the failings made by this scheme in determining Mr Buckle's own application for compensation, or indeed prevent other claims being rejected after similar careful consideration. Now, if the government maintains that it is necessary for a person presumed innocent to also prove it if they are to receive compensation, then the appropriate authority to make that decision, I do not believe, is an official at the Ministry of Justice. Someone who, for no fault of their own, will be unfamiliar with the facts of the case, or has not witnessed the evidence given under oath, but who instead must work solely from the papers. Such an individual is not best placed, Mr Turner, to decide on such applications. Instead, surely, it is the trial jury who are best placed to make the decision as to whether the evidence proved, in this case, Mr Buckle innocent, to be both not guilty and innocent. And as such, I would like to request that the Minister agrees to meet with us to discuss the handling of Mr Buckle's specific application, but also the merits of introducing an amendment to the law to allow a judge to ask the trial jury, in circumstances where they have acquitted the defendant on all charges, to consider also whether they are satisfied on the balance of probabilities that they are innocent of those very same charges. If it is the government's intention to ensure that true victims of miscarriages of justice are fairly compensated, then asking the trial jury to make the decision must be the fairest way for such a decision to be made. And it's difficult to see any rational argument against it. And so I do ask if the Minister could be so kind as to agree to a meeting to discuss how we can ensure that Mr Buckle is granted this opportunity so that this miscarriage of justice and the ordeal he and his family have endured is finally brought to an end. And I would also say that urgency is the key here, Mr Turner, because justice delayed is justice denied.
I remind members that if they wish to catch my eye in this debate to be called to Bob, please. The question is that this House has considered miscarriage of justice compensation. I call the Chair of the Justice Select Committee, Andy Slaughter.
Thank you very much, Mr. Turner. It's a pleasure to be here, I think, for the first time when you're chairing these sessions in Westminster Hall. And it's a pleasure to have heard the speech of the Honourable Member for Ceredigion-Preseli. And I'd like to thank him both for bringing this topic before the committee, but also for the outstanding representation he's given to his constituent, Mr Buckle. I think it's right to say that there are concerns about miscarriage of justice that go beyond compensation. This is a debate specifically on the issue of compensation. That's what I will come on with. But it would be remiss to say, not to note at the beginning of the process, that there are very serious concerns, particularly around the role of the Criminal Cases Review Commission, but also more generally, and I'll come on to the Law Commission report later. I'll say no more than there's been recent turbulence at the top of the CCRC, and that the Justice Select Committee is holding on the 1st of April a public session in relation to that body, on which we may well also touch on the subject of compensation. That's obviously a public session. And I'll just briefly take this opportunity to say to the Minister that we are awaiting the appointment of an interim chair following the removal of the previous chair, or the resignation of the previous chair after a period of time. But we need an interim chair, we need a strong chair. We also need a good process for selecting a permanent chair for that body, and she will know that the Justice Committee has asked to be involved in that process as part of a pre-appointment approval hearing. And I hope that can become. If she's got anything to say on either of these matters today, that will be most welcome. So, yes, it is right that there are concerns about the process for identifying miscarriage of justice, and I'm pleased to see my little friend over Liverpool Riverside, who very ably chairs the APPG on miscarriages of justice here, and no doubt she will say something about this. Because unless we are clearly identifying cases and doing it in a timely manner, then the issue of compensation is even further down the line, or doesn't even come to the fore. And we've heard that the Law Commission is producing a substantial report. It's a very substantial consultation exercise, some 700 pages so far, which looks at both the way that the CCRC operates, and it correctly says that the test that exists for referring cases is a faulty test, or my word is faulty. What they say is that the test, i.e. that there is a real possibility that referred decisions would not be upheld due to a new argument or evidence not raised in the original or appeal proceedings, means that effectively the CCRC is having to second guess the view of the Court of Appeal. And that's something that they're consulting on, and say that they're provisionally persuaded that the current test should be replaced with a non-predictive one. And the second important change that they are putting forward for consultation is that the CCRC should return to what I think was its original intention of having an investigatory function. In so many cases, evidence is presented to CCRC, it isn't looked at in good time, and when it is looked at, it's looked at purely on the merits of what is submitted and not going behind the case, not seeing whether, in fact, there has been substantial miscarriage of justice in relation to this. But let me turn specifically to the issue of compensation. That issue has been added to the Law Commission review, and they have said in very strong terms that they believe the law as it stands is incoherent on that point. I'm just going to read the concluding paragraph in that section of the report, which is paragraph 1675. The current compensation scheme seemingly prioritises minimising the risk of the guilty receiving compensation at the expense of the innocent receiving compensation. Some people who are provably innocent on the balance of probabilities, which would ordinarily apply in civil compensation proceedings, are denied compensation. The stringent requirements of the current compensation scheme seem to be in tension with the overall objective of the criminal justice system. As noted by Lord Phillips, requiring a wrongfully convicted person to prove their innocence beyond reasonable doubt is a heavy price to pay to ensure that no guilty person receives compensation. We consider that imposing a criminal standard of proof on an applicant is indefensible and inconsistent with the fundamental principles that underlie our criminal justice system. That is incredibly strong language coming from a body that is as thoughtful and reserved as the Law Commission. It's also been said that some of the recent and of course welcome compensation schemes that have been devised to deal with the injustices over the Post Office Horizon scandal, and there are 4 separate schemes there, have had to be devised to deal with something that was a national outrage affecting many thousands of people, because the current system simply does not work on its own merits. And all of those factors, I say gently to the ministers, are reason why we have to look at both the issue of wrongful conviction and the issue of compensation for wrongful conditions. Again, it's been said, and I don't want to go over the same ground that's been very assiduously described already by the mover of this debate. But with each passing decade, there have been more and more restrictions. There have been some positive steps, and I have to say that the previous Lord Chancellor, Alex Chalk, was quite right to end the disgrace of those who had been exonerating having to pay for their bed and board while in custody out of their compensation. That compensation is already heavily limited. The circumstances under which that compensation becomes available, it has, as we've heard, become extraordinarily limited. I mean, I'll give one statistic in relation to that. In 2005-06, the compensation actually awarded to victims of miscarriage of justice was £14.6 million. 10 years later, it was 12,000. This is the total sum, £12,493. To all intents and purposes, compensation has ended as far as victims of miscarriage of justice is concerned. Of course, it is not everything. The important thing is to get people out of prison when they are in there wrongly, to clear their names once they have been exonerated. But the financial, material and other damages, including emotional damages, that in any field of civil law would be compensated, they simply haven't been addressed, and that people are still being punished. And I think in the case of Ms. Bucker we heard earlier, they're still being punished despite being found exonerated. The state should be not just apologising and redressing wrong and vindicating people who have been shown to be in that situation. And the idea that the beyond reasonable doubt test is a reasonable test, I think that if there was ever an argument for it, when it was introduced in 2014, then that has been disproved. The rationale was that if somebody was cleared on a technicality, it would be wrong also for the state to compensate them for that. Well, the system is able to deal with cases like that. What it's done is it's caught everybody in its net, including the most deserving cases. And I'm going to conclude on this, Mr. Turner. I think the only thing you have to think about in terms of whether we have a just or an unjust system at the moment is which historic cases would now be caught. At the invitation of the chair of the APPG, I attended a 50th anniversary of the Birmingham Six just a week or two ago, at which there were representatives of many, many other miscarriages of justice. But the fact remains that were the Birmingham Six now being exonerated, or the Guildford Four, or the Cardiff Three, or many other cases, they would not receive compensation. The line has moved so far to one side that in almost every case there is an injustice. Yes, it is vitally important that we get right the way that we deal with miscarriages of justice, whether that is in the Court of Appeal, whether that is in the CCRC, whether it is through legislation. But clearing someone's name, getting them out of prison when they've been undeservedly sent there is one thing. Ensuring that their families and their lives are put back on track requires substantial sums of money, not thousands of pounds, but often hundreds of thousands of pounds, or in some cases millions of pounds. There are arbitrary limits, there are insuperable barriers, and that is itself a grave injustice. And the sooner that we can change that system, I don't know what my friend's going to be able to say today, but within the next weeks and months, we have to see not just a review of the rules and compensation, but a review on the whole way that the miscarriage system functions, and in particular, a review of the role of the CCRC, which appears to have severely lost its way.
Jim Shannon.
First of all, a pleasure to serve under your chairship, and I wish you well in the new role you play. And also can I thank the Honourable Member for Cardigan Priscelli for raising this issue. I watched the Honourable Member on TV this morning, interviewed with his constituent as well, and I think he should be commended and applauded for his efforts on behalf of his constituent to find justice. In my intervention earlier on, I said to him that everyone is innocent until proven guilty, not the other way round, and that's the thrust of what the Honourable Gentleman is putting forward. I just, like himself, can't comprehend that someone who is found not guilty is not guilty, and if the court can't prove it, and the court feel that he should be freed, or she should be free, whatever the case may be, then that's a clear issue for me. As has been alluded to, Northern Ireland doesn't operate under the same scheme as operates in England and Wales. However, we certainly have a scheme which has certainly been accessed as well. Cases can be referred to the Northern Ireland Court of Appeal by the Criminal Case Review Commission, the CCRC. The CCRC, which investigates wrongful convictions in the United Kingdom of Great Britain and Northern Ireland, was set up by the government in response to a number of high-profile miscarriages of justice cases, including, for example, the Birmingham 6, that received some 1,400 applications a year from across the United Kingdom and some 40 from Northern Ireland. So the CCRC is a system where everyone in the United Kingdom of Great Britain and Northern Ireland applies to for if there's been miscarriage of justice. I recently read an article on compensation for miscarriages of justice in Northern Ireland on the BBC, which highlighted that more than £9 million has been paid in compensation since 2010 to 16 people who have had their criminal convictions overturned in Northern Ireland. So there's certainly a compensation system under the CCRC, which seems at least to have compensated those in Northern Ireland, Mr Chairman, and that's why the Honourable Gentleman is right to put forward this, to seek the similar compensation for his constituent. New figures show that some 84 people were wrongly convicted of crimes between 2007 and 2017. Charges range from murder to rape and included people serving the life sentences. At least half of those who had their convictions overturned spent time in prison, amounting collectively to more than 100 years in custody. 30% were sexual crimes, 90% of those wrongfully convicted were men, and indeed 31 cases led to a retrial. However, as someone who is always mindful of the victims, just this week I've been highlighting the issue of the victims in other circumstances, I do think that we must highlight it even in cases where convictions are squashed. The words of a former CCRS caseworker and criminal law lecturer, Dr. Hannah Quirk, should be heard, and I quote her words for the record in the Hansard debate. It is important to also understand what is meant by wrongful conviction. It would be very unusual for the Court of Appeal to say someone is innocent. Instead, it decides whether any new evidence has come to light that makes a conviction unsafe. So not all of these cases will necessarily be about innocence, and more about if the criminal system itself applied the rules fairly at the time, and whether or not, if the trial happened today, that a person would be convicted based on the latest available evidence. I quote that last sentence again because I think that last sentence hopefully gives the very point that the Honourable Gentleman for Cardigan Preseli is putting forward. Whether or not, if the trial happened today, that the person would be convicted based on the latest available evidence. So that's where I believe the Honourable Gentleman is correct to follow the issue of compensation on his and for his constituent. For victims of crime, they need to be ensure that justice is carried out, and unsafe convictions are not justice. And for those who actually are innocent, there must and there should be compensation. The old saying, if there's no smoke without fires, one often used when considering someone's guilt. But this leads to people having to restart their life. And sometimes when a wrongful conviction is put forward in compensation, what does that mean? And I was thinking about that before I came down to the debate. You know what it means? It means sometimes that families have to move home, children to a new home, children to a new school, new job to be sought out for, the mortgage in the house that the one that you're in and how it's going to be taken care of. The issue of compensation is so focal and central to what it has to happen, and for those to have a fresh start through feelings in the system and not through their own deeds, which is what the Honourable Gentleman referred to. I do believe that it is right and proper that there's help to start this new life for those who are genuinely innocent. However, in saying all of this, I also agree that the criteria for this compensation must be strict, and it has to be. And we're not saying that it shouldn't be, but whenever there's a clear case of innocence, then there should be no reasonable doubt from impartial eyes. The Troubles compensation for Northern Ireland victims has been skewed in that perpetrators of crimes can also receive compensation for those crimes that have been committed, where we could have, for example, Jerry Adams receiving compensation, or Jerry Kelly, who shot a prison officer in the head during a prison escape. These people should never, ever receive a single penny with our King's head on it and adoring it, and that's why we must retain a very close scheme for these matters. But where there's a clear case, as there is, and the Honourable Gentleman has illustrated that very clearly in his the coverage in the TV, coverage in the radio, and today in this House, where he put forward an admirable case on behalf of his constituent. I support, Mr. Chairman, I conclude with this, I support access to redress, but not for any purpose, and I do believe that the judiciary must continue to have the courage of their conviction and be supported to deliver real justice in every way possible. Thank you.
Thank you. Kim Johnson.
Thank you, Mr Turner, and it's a real pleasure to serve under your chairship today. And I'd like to start by thanking my honourable friend, the member for Ceredigion, for securing this very important and timely debate, and for the vital work he is doing in support of his constituent Brian Buckle, and by extension all victims of miscarriages of justice, including those convicted under joint enterprise. But I'd like also to declare my interest as the chair of the APPG Miscarriages of Justice. And Mr Turner, as mentioned, earlier this month I held an event in Parliament to commemorate the 50-year anniversary of the conviction of the Birmingham 6 and to remember the Maguire 7 and the Guildford 4, all of whom were wrongfully persecuted and convicted, and all of whom fought tooth and nail for exoneration and for justice. We heard some harrowing testimonies from Paddy Maguire, just 13 at the time of his arrest, who suffered immense police brutality and served time for his alleged handling of explosives. He and his family were eventually cleared of all wrongdoing, but the scars still run deep. We hope to hear from Paddy Hill, a titan of the justice world, who dedicated his life not only to clearing his own name, but to fixing the systemic issues that facilitated his wrongful persecution and prosecution in the first place. Unfortunately, he passed away in December last year, and I'd like to take this opportunity to pay tribute to his life and his work. Paddy was wrongly imprisoned for 16 years following the 1974 Birmingham pub bombings, in one of the most profound examples of injustice in the UK legal system. And following his arrest, he campaigned tirelessly for justice on behalf of other wrongfully convicted prisoners. His dedication and the widespread outcry after the wrongful convictions of the Birmingham 6, Guildford 4 and Maguire 7 led to the establishment of the Criminal Cases Review Commission to prevent similar injustices. It was the first state body in the world established to help those convicted who claimed to be innocent. However, as we've heard, years of cuts and overlap in personnel with police and courts undermined the CCRC's effectiveness and independence, with many recent scandals, including the outrageous case of Andy Malkinson, who served 17 years in prison for a rape he did not commit in what has been called one of the worst miscarriages of justice in the UK legal history. In the months leave in prison, Malkinson was reliant on food banks and universal credit, suffering from mental ill health due to his wrongful conviction. And last month, he was finally awarded a six-figure sum as compensation, but he is one of only a handful of people wrongly convicted of a crime to be compensated in recent years. And since the 2014 overhaul of the compensation policy by the coalition government, the bar has been raised insurmountably high for most victims for wrongful convictions. The result has been a virtual halt in all compensation payouts for these devastating miscarriages of justice. In reality, only those who can demonstrate that new DNA or alibi evidence proves that they did not commit the crime will receive compensation, an absurdly high threshold, one that reverses the burden of proof and does not reflect the principles of just law, and is in practice impossible to achieve for the vast majority of cases. Between 2020 and 2023, the MOJ paid out less than £1.3 million in compensation to victims of miscarriage of justice, following a 2-year period when not a single penny of compensation was paid out. To put this in context, between 2007 and 2009, A total of £20.8 million was paid out. With the Post Office Horizon scandal and the Invected blood scandal, we know that public sympathy and support for victims of miscarriage of justice is strong. The principle of fair justice is universally held, but these should be the true rule, not the exemption. We should not need significant political campaigns and interventions from the top for justice to be accessed. Our justice systems should work according to the law and the principles they were founded on. And where wrongdoings are done, there should be checks and balances in place to ensure that justice is achieved. Instead, we are seeing significant backlogs in the CRC and only a trickle of cases making it through to the Court of Appeal. While the recent resignation of the Chair is welcome, we know there are systemic failings and a lack of funding that reveal the need for a complete overhaul, not just a change in leadership. Cases like the Birmingham Four are still awaiting a decision on their application to appeal. People who believe they can prove they're innocent and who have a right to appeal their convictions are rotting in jail while the system creaks. If the public is to have confidence in the underfunding and struggling criminal justice system, it needs to have confidence that the processes are both fair and appear to be fair. Checks and balances are needed throughout the system, and these need adequate resourcing and support. Miscarriages of justice ruin lives, not just for the victims themselves, but also their families and loved ones. Compensation must be paid where compensation is due, and victims should not have to wait and fight for years to secure it when they have already been put through so much. The British legal system is supposedly predicated on the principle innocent until proven guilty. I hope today's debate will help us to get back to this principle and to make sure that those who have been wronged have access to justice. Thank you.
Under Just.
Thank you, Mr. Turner. It's a pleasure to serve under your chairship, and I wish to thank the honourable member for securing this important debate. I also want to declare my interest as a member of the Justice Select Committee. I read about Brian Buckles' case this morning, and I wish to express how sorry I am for what he went through and the injustice he and his family has suffered. Compensation payments awarded to miscarriage of justice victims can be life-changing for the individuals involved. As a solicitor before I became an MP, dealing with negligence cases where I pursued claims for compensation for clients who had suffered injustice, I can appreciate how important compensation can be for victims who have suffered miscarriages of justice. My honourable friend for Hammersmith and Chiswick mentioned that such cases are not just about compensation, and he has mentioned the Law Commission report, which I will not repeat here. But just as important as obtaining financial compensation, Mr. Turner, it is also important to understand the need to have access to justice so that those victims of miscarriages of justice can have their names cleared and have their experiences acknowledged, and so that there is recognition of the harm inflicted upon them and their families, together, Mr. Turner, with a commitment to prevent injustices in the future. Very often in my career as a solicitor, I came across clients who had been very badly injured, but what they wanted ultimately was a proper apology, an acknowledgement that they have been wronged, rather than seeking maximum levels of compensation. Access to justice is something that we as parliamentarians should be advocating. The Antisocial Behaviour, Crime and Policing Act 2014 means that those who are wrongfully convicted must not only overturn their conviction, but they also have to then prove that they are innocent beyond all reasonable doubt in order to be eligible for financial compensation. This unfairly reverses the burden of proof, where a person is presumed innocent until proven guilty, and where a person's guilt must be proven beyond all reasonable doubt. Mr. Turner, this reversal of the burden of proof makes no sense at all and is indeed contrary to the basic principles and rules of criminal justice in this country. Mr. Buckles' KC, Mr. Stephen Vulu, actually said that he believes that the law was changed in 2014 in order to ensure that money would not be paid out to victims of miscarriages of justice, and that it was a policy decision deliberately made to avoid the payment of compensation. So it's therefore no surprise that following the Act, there's been a huge decrease in the number and value of compensation payments that have been awarded. During the period between 2016 and 2024, out of a total of 591 applicants, the Ministry of Justice only compensated 39 claimants, representing a rejection rate of over 93%. The law needs to be changed, Mr. Turner, because justice and the opportunity for redress must be given for all in our society. A former criminal defence solicitor and a specialist in miscarriages of justice at the University of Manchester, Suzanne Gower, said that the current system is inhuman and cruel and sends a message that the state will not and does not accept responsibility when it causes harm, which is clearly wrong. Whilst it is essential that proper compensation payments are made so that victims of miscarriages of justice can also recover the costs that they have incurred in proving their innocence and being compensated for all that they have suffered, together with historical injustices also being corrected, Mr. Turner, more needs to be done to ensure that we prevent these incidents from occurring in the first place. We need to learn lessons about why things have gone wrong by investing in investigative processes, ensuring accountability within institutions, and by promoting a culture of transparency. Not only will these measures save the government and also the taxpayer from a financial burden in the long run, but crucially, it will prevent more people from being harmed and prevent further miscarriages of justice from occurring in the future.
Thank you. Lib Dem spokesperson Josh Babarinder.
Thank you, Mr. Turner. It's an honour to serve under your inaugural chairmanship, and I look forward to speaking in a number of debates that you chair over the weeks, months and years to come. And I congratulate the honourable member for Ceredigion Preseli for securing this debate, a debate whose focus strikes at the heart of our justice system, principles of fairness, accountability and the duty of the state ultimately to right its wrongs. And there's no two ways about it. Those who have been wrongfully convicted are not merely victims of an unfortunate mistake. They are victims of a gross failure of the state. These individuals have lost not just their liberty, but their livelihoods, their families, their reputations, their dignity, and much more. And for all the talk about compensation today, what we do know is that no amount of money will be able to restore the loss of such profound dimensions. But on the subject of compensation, the Miscarriages of Justice Compensation Scheme was set up with the best of intentions to ensure that those who have suffered the gravest injustice are properly compensated. But as we've heard today, and we've heard beyond this chamber, this system has come to perpetuate the injustices that it's meant to be putting right in the first instance. How? Well, again, we've heard, because in cases where a person's convictions are quashed, our system forces them to jump through acrobatic legal hoops to access even the most basic financial redress. And we've heard about the case of Andrew Malkinson, who spent 17 years in prison for a conviction that transpired to be unsafe, and who beyond that had to wait years to get his first tranche of compensation and is still waiting for the rest. These kind of waits and these kind of injustices are a national disgrace, not least because they are experienced by so many across our country. and some more people who have been mentioned by the Honourable Member for Liverpool Riverside, who have experienced such gross injustices, are those sub-postmasters and sub-postmistresses who were wrongly convicted in the Horizon Post Office scandal, like Kathleen Crane, the former sub-postmistress at Old Town Post Office in Eastbourne. She was wrongly convicted of fraud, made to pay back, in inverted commas, £18,000 that she never owed before her conviction was overturned last year. And in spite of the injustices that those who were caught up in this scandal faced, the Horizon Convictions Redress Scheme and the Horizon Shortfall Scheme, both special compensation schemes set up, have been paying out compensation at a much too slow pace, which is a great dishonour to those who were unfairly convicted. And in fact, I thought the Business and Trade Committee put it really aptly when they said of the process that it was akin to a second trial for victims. Now, many folks in this chamber and beyond, across party political divides, have campaigned for a long time for a fairer approach to addressing miscarriages of justice, and Liberal Democrats are proud to have been part of that tradition, and we continue to be. We believe that when the state wrongfully convicts an individual, it has a moral and legal duty to provide full and proper compensation without unnecessary bureaucratic barriers or those that undermine fundamental maxims of our legal system. So that's why urgent reform is necessary. We must ensure that compensation is granted promptly without re-traumatising legal battles for people, and that it reflects not just the financial cost but the emotional and psychological toll of wrongful imprisonment. And so when the state gets it wrong in such a profound way, it must have the courage to put things right. And I'd like to conclude my remarks just by touching on, I think, a really insightful comment that was made by the Honourable Member for Strangford about victims and survivors. In my view, what we are talking about today and being passionate about correcting the injustices that we're hearing about today is not incompatible with supporting those victims and survivors who are brave enough to come forward, who report what's happened to them to the police, who take what's happened to them to the court, but who ultimately don't get the conviction that they hoped that they would secure. It is critical, in order to have a criminal justice system that works for those victims and survivors, that everybody can have confidence in the way that it functions. And that is on both sides of the dock, both sides of the courtroom. So I very much look forward to hearing from the Minister for her take in this. But again, I congratulate the Honourable Member for Ceredigion-Preseli for securing this debate.
Opposition spokesperson Dr Kieran Mullen.
Thank you, Mr Turner. It's a pleasure to serve under your chairmanship, and I want to join everybody else in congratulating the member for Ceredigion and Treveli for securing this debate and putting it front and centre of the Justice Minister's timetable, which is always an important achievement in Parliament on any matter. And he's done an ample job in representing his constituent, and we've heard today about his experiences. The UK's justice system overall is one of the most highly respected in the world, built on a long-standing foundation of trust in and respect for the rule of law. At the heart of that trust and respect is a belief in the ability of the law to right injustices, including those caused by the justice system itself. Ensuring that miscarriages of justice are rectified is vital to preserving that belief, and providing compensation to victims where appropriate is an important part of the process. Work began under the last government to reform compensation for victims. In 2023, the then Lord Chancellor Alex Chalk removed existing guidance on miscarriage of justice compensation, first introduced in 2006, allowing for deductions on saved living expenses while in prison, applying to all future payments with immediate effect. This common sense change was vital in restoring fairness to this aspect of the compensation schemes. Legal aid reforms brought forward by the last government have also been important in improving fairness and reducing delays to compensation applications. As a result of these new reforms, payments made through the miscarriage of justice compensation scheme now no longer make people automatically ineligible for legal aid, helping to improve access to justice for those wrongly convicted. In light of the concerns raised around miscarriages of justice, a comprehensive set of data on compensation applications was made available by the last government. This data has proved vital in informing the ongoing debate on compensation for wrongful convictions, and I urge the government to show similar transparency in this area as well as we go forward. It remains clear that a comprehensive assessment of miscarriages of justice was needed, which is why the government asked the Law Commission to review the law relating to criminal appeals in criminal cases. This review has since expanded to also include compensation for wrongful convictions and has raised a number of important points. I understand that the Law Commission's review focused particularly on whether the UK is meeting its obligations under the International Covenant on Civil Rights and Political Rights. The Law Commission has now recommended a number of reforms to compensation and support for the wrongly convicted, including replacing the requirement to prove their innocence beyond reasonable doubt, which is an issue of considerable focus today, with only needing proof of innocence on the balance of probabilities to receive compensation. It's important that these proposals are thoroughly considered before any final decision is made, and I welcome the ongoing consultation being carried out by the Law Commission to this end. It is important that the additional costs any changes to miscarriage of justice compensation would entail are thoroughly assessed and understood, and I urge the government to conduct a thorough cost assessment of any proposed changes and to make this data publicly available for scrutiny before any final decision on reforms to compensation are taken. I'm sure that all members here would agree on the importance of providing appropriate compensation for the victims of miscarriages of justice. I would urge the government to consider the responses to the Law Commission's consultation carefully and consider how we might better support the wrongfully convicted.
Minister.
Thank you, Mr Turner. It is a privilege to serve under your inaugural chairship here today, and what a very important debate for that to be. Can I also place on record my sincere diolch yn fawr iawn to the member for Ceredigion Preseli for bringing this important debate to this place and for highlighting the case of his constituent, Mr Buckle, and his family today. Fairness is a core pillar of our justice system. Whilst thankfully miscarriages of justice are very rare, when they happen, they do have a devastating impact on those who suffer them. They are the victims of the state, and so it is right that the state should help and support these people in rebuilding their lives. It is also right that we should seek to redress the occurrence of miscarriages of justice and reduce them by learning lessons when things go wrong. Ensuring people are better protected from miscarriages of justice is one part of the government's plan for change. Any miscarriage of justice is a tragedy, both for the person who is wrongly convicted and, as we have heard from the Honourable Member for Strangford and the Liberal Democrat spokesperson very eloquently, for the victim of the original crime and their family who have not seen justice done. As the Minister for Victims and Violence Against Women and Girls, I know how important it is that victims have confidence in the criminal justice system and that we have safeguards in place such as the Court of Appeal and the Criminal Case Review Commission, and we work hard to make sure that when errors do occur, changes are put in place to prevent similar cases from ever happening again. The last year, as we have already heard today, has seen some miscarriages of justice which have shocked all of us as a society, including the Post Office Horizon scandal and the appalling case of Andrew Malkinson, convicted of a crime that he did not commit. Whilst these cases are the exception, they do require serious and swift action, which we are taking. The Lord Chancellor has met with Mr Malkinson to hear how his case has affected him, and following her meeting with him, she has acted swiftly to ensure that those receiving a compensation payout for a miscarriage of justice will not have their financial eligibility for legal aid affected. The Lord Chancellor has stated her conviction that justice must be a reality, not an ideal, and I wholeheartedly agree. Following the agreement of Parliament to overturn the Postmaster's conviction, this government acted swiftly to stand up a compensation scheme specifically for those affected. As of February this year, 273 final claims have been paid and 407 interim payments, with the government issuing £190 million in compensation. Now, as I turn to the issue of compensation, which is what this debate is about, I feel it is important at the outset to clarify what we mean when we talk about a miscarriage of justice. The Court of Appeal is a vital safeguard in the criminal justice system, and if someone appeals their sentence within the time limit, which is normally 28 days, and the Court of Appeal overturns that conviction, then that is the system working as it should to correct any errors. That is not a miscarriage of justice. Our interest, and the interest here today, is in those who have exhausted that usual appeal process and have often referred themselves to the Criminal Case Review Commission. If the CCRC find that there is a real possibility that the Court of Appeal will not uphold the conviction, they will refer the case. If the conviction is then overturned, the person may have a qualifying miscarriage of justice for the purposes of compensation. I think it's important to outline that here. The Miscarriages of Justice Application Service, known colloquially as MOJAS, pays compensation to those who have suffered a qualifying miscarriage of justice. References today to a 93% refusal rate do not necessarily provide the full picture, because the department routinely receives applications from people who do not pass that initial triage stage. Reason for this may include that they had their conviction overturned simply following an in-time appeal, or that they had not had their conviction overturned at all, and in some cases there is no criminal conviction in the first place. In the last 6 years, until April 2024, as highlighted by my honourable friend, the member for Wolverhampton West, 591 applications were received, but only 133 passed the triage and were eligible for full consideration. And of those, of the 133 applications that passed the triage, 39 have been awarded compensation, with the government paying out £2.4 million. Now, there is understandably some debate about where the line should be drawn for the purposes of compensation, and I'm grateful to the contribution for the Honourable Member for Strangford for outlining that in his contribution. However, I would highlight that there are a number of reasons why someone might have their conviction quashed on appeal, and we believe that it is right that there should be a process by which eligibility for compensation from the government should be assessed. This will ensure that taxpayers' money is used appropriately and effectively. The test is designed so that only those who can demonstrate that their conviction has been reversed on the basis of a new or newly discovered fact which shows beyond reasonable doubt that they did not commit the offence can receive compensation from the state. Now, in the 2023 European Court of Human Rights judgment that was mentioned by my honourable friend, that test by which eligibility for compensation is assessed in the case of Nealon and Hallam. Now, in its judgment issued in 2024, the court found that the test did not breach applicants' rights under Article 6, specifically the presumption of innocence. MOJAS is just one route by which someone whose conviction is quashed can receive compensation or support. For example, it may also be open to someone to bring a civil claim in cases where a particular agency is at fault. Support is also available through the Miscarriages of Justice Support Service, which is part of the Citizens Advice Bureau, based at the Royal Courts of Justice. The support service provides advice and support to those who have had their convictions quashed to help them rebuild their lives. This could involve helping someone find accommodation, assisting with benefit claims, or signposting to psychological support services. Anyone who has had their case referred to the Court of Appeal by the Criminal Case Review Commission is eligible for this support. I would also like to highlight the work we are doing in this area, both to reduce the occurrence of miscarriages of justice and to improve the government's response to them. The Post Office scandal highlighted the lack of oversight of prosecutions brought by private prosecutions. On the 6th of March, this government launched a consultation on the oversight and regulation of private prosecutions, with the aim of ensuring that any organisation bringing a private prosecution is doing so according to rigorous standards and is subject to appropriate scrutiny. In addition, we have launched a call for evidence on the use of evidence generated by software in criminal proceedings. This is to inform potential reforms to the law to ensure that evidence produced by software can be properly assured. As my honourable friend mentioned, the Law Commission are currently consulting on a wide range of changes to the laws relating to criminal appeals. Their consultation is rigorous, with over 100 questions. This includes questions on compensation for miscarriages of justice, and we do look forward to their final report in 2026, and we will consider all of their recommendations in the round before deciding on any reforms necessary. This government is committed to ensuring that the process is fair for all involved in the criminal justice system, and a key part of that commitment is the effectiveness of the Criminal Case Review Commission, who carry out the vital work in investigating potential miscarriages of justice. As highlighted by my right honourable friend, the Chair of the Justice Select Committee, the Secretary of State is in the process of recruiting an interim chair, and that is a matter of priority. The interim chair will be tasked with conducting a full and thorough review of how the organisation operates. The findings of this review, together with the final report of the Law Commission, will provide us with the evidence that we need to ensure that any change we make to the system will promote fairness and justice for all involved in the criminal justice proceedings. On the point of a meeting, I will ensure that that request is passed to the Department of the Minister of State, who is responsible for this brief. Unfortunately, she cannot be here today as she is in Bill Committee for the Assisted Dying Bill, but I will ensure that is passed through, and I will also be taking a keen interest in the case, and I'm sure my honourable friend will be mentioning it to me at any opportunity. It is an important principle, Mr Turner, of the justice system that people who are convicted should have the right to seek leave to apply to a higher court to review their conviction. It is also vital, in the rare cases where things do go wrong, that the system works effectively to correct errors and ensure that those who have suffered are able to rebuild their lives. I emphasise again, when the wrong person is convicted, it fails both those who are wrongly convicted and also the victim of the original crime. This government has acted, and it will continue to act to ensure that the lessons are learned and that justice is done. Thank you.
And Lake, to wind up, please. I'll give you 2 minutes.
Mr Turner, can I begin by apologising for failing to acknowledge that this is indeed your inaugural session in the Chair, but can I just say how admirably and actually professionally you've done it, especially given that we had the unexpected interruption of divisions, and so thank you very much for doing so. Can I also thank my fellow members from every part of the United Kingdom for their contributions, and how heartening it is to hear a great degree of consensus here that there is a wrong to be righted, and that the new government has the opportunity of doing so. In summing up, Mr Turner, I would just make a few very quick points. We do have this opportunity of righting this very clear wrong. There are far too many people who have had their convictions overturned, but also then found not guilty at retrial, having spent years imprisoned, that are still awaiting compensation. We also then need to appreciate that any delays to this justice is also effectively justice denied. And so, whilst appreciating the need to proceed with caution and reasonably, we do also need to make sure we do not waste any time, because too many of these individuals have already suffered ordeals for far too long. And I suppose the way that I would sum this up is that we have an opportunity here, as members of Parliament and a new government, to do something that I think is very honourable, and something that a far more honourable member than I, who sat just over here, once told me, that we are sent to this place, Mr Turner, to right wrongs. I think today there's a great consensus in that endeavour.
Thank you. The question is that this House has considered miscarriage of justice compensation. As many as are of that opinion say aye. Aye. And of the contrary, no. I think the ayes have it. The ayes have it. Thank you.